I got an interesting question, and I've never heard it put this way before, but it's like, Carmen, what is the 20-day foreclosure clock? And it came from Mary in Naples. Mary, a great question. The 20-day clock I think you're talking about, well, there might be two. The 20-day clock, the first one, is when you first get served with the lawsuit. The statute says, or the service of process statute says that after you receive that lawsuit, you have 20 days to file a response from the day after receipt. And they don't want to prejudice anybody by saying you have 20 days from the day you receive it. What if you receive it at 8 o'clock at night on a Friday night? Well, then your clock starts ticking Saturday morning, the day after receipt. That's day one. Then you've got 20 days, calendar days, not business days, to file a written response to the lawsuit. I guess the legislature feels that 20 days is fair and reasonable. But you may get a lawsuit. If you do get a foreclosure complaint and it says 30 days on it, that you have to respond in 30 days, that is probably due because the lender or the attorney does not want to run afoul of the Fair Debt Collection Practices Act. So many attorneys have decided, you know what, I'm not even going to play this game. Recently there was a ruling by the 11th Circuit that said the act of attempting to collect the debt in foreclosure is debt collection activity and is subject to the Fair Debt Collection Practices Act. So foreclosure attorneys, be careful. So a lot of foreclosure attorneys are putting in 30 days instead of the 20 days by statute just to get themselves outside that 30-day window so that their consumer can't come back and say, hey, you violated the Fair Debt Collection Practices Act. Again, I understand that line of thought, no problem. Then you have 30 days outside the 20-day clock. The other 20-day clock that I think you might be talking about or could be talking about, and this is from Mary, Mary, is the 20 days from the date of the final judgment to the date of sale. There's another 20-day clock there that says that, let's say, for example, you're in front of Judge Fuller or Judge Kyle, and they say, okay, 20 days till the date of sale. Here's a final judgment. Boom. 20 days till the date of sale. The statute says you have to have at least 20 days to the sale date. Now, many of our clients have been successful negotiating with the other side and asking for extended sale dates due to the fact that they're modifying the mortgage and they just need another 30 days. So both parties agree to set the sale date 120 days later. The judges are okay with that. They sign off on it. But then you're really under the gun to get that foreclosure sale taken care of or stopped because you get the mortgage modified. Those are always dangerous proceedings. It's kind of like a crapshoot, but you got to get in and do it.